are going to be managing time in terms of managing 12 minutes or so. 22 minutes or so. May I just pose some questions to panel members here before we can ready ourselves in asking questions? And when we come to asking questions, we would identify in each block how many we have to take, and then go to the next includers and conclude as such. I would hope that we will be able to cover about time. In case we want to comment, may I suggest that in our comments making reference to your own context, we ultimately identify exactly what we want to be saying upfront, a consolidated statement, and then we can elaborate after it, in terms of digesting the issue that we could be raising. Martin, you have raised an interesting aspect about the research method as far as the pre-trial detainees are concerned. And in giving the comparison that you have just outlined, I just want to hear from you in terms of the recommendation that you can give attendees here on the alternative approaches that are there, which can help countries to have a sort of a base of reference of information to be used to motivate young ones in as far as funding for the is concerned. And with the understanding that countries, as you said, are differently resourced. Sometimes those in authority will view that the other aid is crowding out other social needs. But in interplay of, if they don't fund this, then what happens with all the ailments that we can everywhere? Give us a sense further of what you would recommend as an approach.
Okay, no, thank you. It's a very good question because unfortunately, it is, in fact, in most countries that we are dealing with a politically very unpopular constituency. Politicians have very little to gain by spending money on people who have been arrested in pre-trial detention or waiting trial. They have potentially a lot to lose because the public might perceive them to be soft on crime. And that's a very genuine issue, including in South Africa, where crime, violent crime in particular, is very high. The public legitimately is concerned about crime. So I think the argument that one should try and make is first to try and cost what does legal aid actually cost. Some countries will know that figure, but in other countries, as we heard, governments are not even quite aware what it is they actually do spend on legal aid and legal assistance. But then more importantly, to try and do what my colleagues and I did, to try and put a monetary value to what the consequences are of not providing legal aid assistance. And one can do that in different ways. One can show the direct monetary implications of cost to pre-trial detainees, which are obviously very significant. But if one thinks that in your own country that's not going to be politically very appealing because there isn't much concern about the well-being of pre-trial detainees, then extend the argument to their households and families who are genuinely innocent and not blameworthy, for whom the public has greater sympathy. And even beyond that, what are the public health implications of detaining a large number of people, which could affect prison wardens and generally members in the community, exacerbate public health problems, which will over the long term create a lot of financial problems and concerns for the states concerned.
Right, the Ukrainian experience as far as outsourcing legal aid services to private or so to say, other jurisdictions they call it jurisdictions. Among other issues, there is a challenge of how you control those who are outside justice. And especially when you expect them to provide a service to the public, and you also have confidentiality of a practitioner and client relationship, and then at the end of the day, you've got to pay. You've got to pay when they say they have provided the services. Can you give us a sense of instruments maybe or some measures that from Ukraine you have just set up just to make sure that those pitfalls at least are being addressed?
Thank you for the question. It's probably not so easy to explain how this system is work out with those who outside privilege. At the time being the law on privilege in my country is supposed that every detained person has right to privilege. As such, in this case, for example, we don't have any disturbances of existing of people who are arrested, for example, but are not compliant with criminal law. In this regard, the main problem in Ukraine is the obligation of the police to inform us about the cases of abuse. In terms of provision of regulated criminal procedures for the decision, the requests for criminal aid usually comes from court or from investigator or from prosecutor. Our role in such a case really seems to make quite deep and targeted information campaign just to give the people understanding that they have the right for criminal aid. We try to put the police on the position that they should have such information to the list of the information that they provide to people, to persons as a must. So if they, for example, inform a suspected person on his or her rights, the right to apply for criminal aid should be obviously essential. We also try to engage our ombudsperson in Ukraine for such work and to keep the person on our side in this work with the Ministry of Interior. With regards to confidentiality, I would like to highlight that the state center is obliged to assign lawyers to criminal case. We do not put our nose into the sense of the criminal procedure. This is the case of the lawyer and the client to agree to petition on the criminal procedure.
Thank you very much, Lieutenant. Just on a lighter note, as a host of the FIFA Circle, right? It reminds me of our experience in 2010. South Africa was hosting the FIFA World Cup. And one of the greatest challenge was for South Africa to set up special courts. And they're setting up special courts in the sense of the certain individuals who are always some tendencies of control. And ultimately then they find themselves incarcerated. And then a means was supposed to be set up, and legally South Africa was called up to say, what would you do in that case? Because people are coming from outside the country. But on that light note, I would hope that Brazil is going through probably the same situation. When there are constitutional provisions within, in a as far as it relates to the provision of legal aid, I'll raise this question. The issue that arises, and it has been raised even in the plenary, in the ID for the speakers, is an issue around what one can call relatively adequate or sufficient provision of budget to cover for it. And you talking about the federal state making sure that constitutionally there is a provision of legal aid. But the question that arises is, what is seen as adequate or sufficient relative to many needs that could be there from the perspective of Rosie?
Thank you for your question, and I can continue my presentation. The time is short to comprehend. At first, I'd like to say that I love soccer, but I don't have the same relation with FIFA. I couldn't even buy a ticket to watch
You are here.
the games, and I'm here. And I'm here also. They tried to do the same special courts, but they couldn't. And only to notice that FIFA invited judges and prosecutors to the games to watch, not to watch, supposed to work during the games, but of course not working during the games. They invited many judges, many prosecutors, and no one of us, no public defender was invited. It's the experience of hosting the World Cup is really impressive. In such a way, it's very good, and many others no. And people is struggling a lot because of the expense in this World Cup. About the public defense and your question, first I'd like to say that in Brazil, as Maha told us, in Brazil we invest less than $4 per capita in legal aid system, in public defense, more precisely, in public defense. But it's not the same in all over all the states of Brazil. In the state of Rio, I know the budget, we spend almost $13 per capita. That is really impressive comparing to the investment of Brazil. So we have a population of 16 million inhabitants and a budget about $250 million. It's important. I think it's the biggest budget of public defense, of public defense in Brazil. And comparing to the judges and to the prosecutors, I can say that we have in Brazil 12,000 judges, and in states, not the federals. The federals are like 1,000 judges, but comparing the states, federals, we have 12,000 judges. We have 9,000 prosecutors, and we have 5,000 public defenders. And this number of public defenders increased a lot in the last 10 years, because it was less than 3,000 public defenders in 2001, 2002. So for this number of professionals, 12,000 judges, 9,000 prosecutors, and 5,000 public defenders, we have a budget that, comparing to the state budget, the judiciary spends about 5% of all the public budget. 5%. It's really big. The prosecutors spend 2% of the whole public budget. And the public defenders, the Office of Public Defenders, spend less than 0.5% of this budget. So the balance of justice is not equal for sure. We must invest more in public defense and even to provide the service to all over the country, because we have the service provided in many, many cities, but not all the cities of our country.
Thank you very much. Well, just as we talk about the kind of arms, that's one critical aspect I think countries are facing. Just as a matter of insight from the U.S. standards as well, is there anything that maybe could be said about how the United States amass information that can be utilized as a point of reference to balance this inequality, especially because with the public defenders not fully exhaust the prosecution on the other side, having a better side of resources.
Thank you. Yeah, I mean, this is the constant struggle and the difficulty, and it has a lot to do with what Martin said, that there's a sense of being tough on crime. This is a big thing in our country, and also in our country, if you're a felon and you're incarcerated, you often lose your voting rights. So there isn't a constituency really for politicians to feel that they want to advocate on their behalf. So, the equality of arms is a constant struggle. I think one thing to consider is again, a reference the Associate's keynote this morning. He referenced some policies that are different from funding. So funding, we struggle, and everyone in the past year, in fact, our Congress and the executive branch, we had a government shutdown, and it was quite a disaster. So it becomes difficult to try to ask for more money on an unpopular topic when in fact everyone is losing money all across the board. So there are opportunities, in fact, to find ways of addressing some of these issues outside of sort of the traditional money for them and money for the other. So if there's ways to reconceive of sentencing policies within a country, or there's ways to think about clemency. There are these policy initiatives that the federal government, or perhaps states, but again, it depends on the system, that can actually try to create more balance in the system and alleviate some of the pressure, especially with the high rates of incarceration in the United States and our overcrowded prisons. So sometimes we have to look outside of just simply saying we need money. Sometimes we have to be creative and identifying ways that can really try to limit the harms of sort of the imbalance in our system.
Thank you. On that very note, we will now have an open question and answer session. And by show of hands, can I see where you start? And we have a roaming microphone. Oh, you have them in front of yourselves. Can we start this side?
I'm Madhurima. I have a question for Martin. I just want to know, have you done any studies? Like, you've done a study showing how much countries are spending on pretrial detention. But is there any studies that shows that when you increase the money that you're giving to legal aid, then that actually reduces the cost of pretrial detention? Like, is there any state, or are there any examples of any countries where you've seen that if you have a much more effective legal aid system and you're paying more in the legal aid system, then the cost of pretrial detention is actually reduced?
Then we are going to countries.
I'm from Kyrgyzstan, and we're currently actually at the stage when we are developing a new law for legal aid, and we are also deciding on the size of it. And it has, of course, a lot depends on the much developed also whether the availability of the budget innovation within itself the size of the
I'm Roland Korean is also there. Martin, thank you very much for that research. I would want to, a small question and a comment. I want to know how extensive research was. I saw a few countries, on the board. And then, secondly, now the comment, for me, the findings appears to, first of all, it's, for me, very revealing and also depressing, because it connotes the wider, society in which we live. For me, it could also read the effect on poverty, or the effect of poverty and crime, because when I look at the statistics, you will see that it is mostly people who are under economic pressure that come into brush with the law and are also incarcerated. So for me, it reveals the wider failure, not only one of the global criminal justice systems which operate, but also two, the social systems, the social orders. We have probably so much spent on prosecution, on policing, etc., whereas in relation to defense, there is not so much. So, in other words, the concept of equality of arms, has not featured very well. You have situations where there is very much little spending on even people who are in mutual detention, and at the end of the day, it becomes a vicious cycle. You have a situation where people are incarcerated, poor people, and then there is very little form of reform. They are released back into the same society with lack of skills, with no employment, and as a matter of fact, to have a vicious cycle. So I think this should raise a lot of questions of the societies that we have, social orders, and in quite a lot of these countries in which we talk about the lack of resources, etc., we want to see that defense budgets. Very shocking. So, to a large extent, when governments say that we do not have money for me, most of the time I think that we should, those who are practitioners should also be able to push the envelope further, because I think more could be done. Thank you.
How many hands are still on this one? There's a phone you
Thank you for the panel. Firstly, I'd like to raise some questions to the Green, particularly on the newly started program. Also, the second question also to the Green, the third question actually goes to the panel. Firstly, I'd like to understand what is the vision of the government to really come to agree, firstly, on the speed aid provision, and secondly, the increase of the budget. And thirdly, how do you actually work it out in terms of the attitudes of the lawyer? So one, there's also private lawyers who are treating clients. There's also might be the kind of potential clients receiving better free legal aid services from the same lawyer, and what are the attitudes and how do you really manage that? So the final question actually goes to the panel is actually about when you talk about financing, you also have to look and think about value for money and how do you really monitor and judge the value for money of the cost and also some of the relationship of the country overall and other countries. Thank you.
Thank you very much. Questions raised? As the panel just to respond to Martin, we have two there. You can go one after the other. And after the picture, you can respond to it.
LGBT violence, which is
And you find those in my watching and jail. I can urge only
Thank you. Madam, you asked a good question. So there is some evidence that as one invests more in aid, there is a reduction in the number of people being placed in pretrial detention, and maybe even more significantly, the average duration, the median duration of people spending in pretrial detention. The cost implications are actually less in more wealthier countries than they are in poorer countries. And that is because in wealthier countries, the cost isn't so much borne by the families, but rather by the state. And the bulk of their cost is the infrastructure, the prison building, the prison wardens, and so forth. States cannot quickly dismiss people, retrench prison wardens just because fewer pretrial detainees are coming in. So there the cost isn't as significant. Where it is much more significant is in those countries where the cost is primarily borne by the individuals and their families. In poorer countries, in developing countries, there for every person who's released, some 4.5 dependents on average in the 3 West African countries who did our research, we suddenly have a breadwinner who's back contributing to the household. However, it's never quite as simple as that, because what we found in a number of the countries where we did the research, while the additional lawyers or paralegals did reduce the duration and the number of pretrial detainees, very often there was a lot of corruption in the police service, of course. And as quickly as the lawyers were releasing, as quickly the police were rearresting people. So that the absolute number of people in detention didn't actually change very much. They were there for a short period, but the prisons were still as full as always because the police had a financial incentive to arrest. So unfortunately, the solutions to these problems are not as easy as I might seem on paper. Really deep systemic problems troubling these criminal justice systems, which make them a bit more tricky to fix, otherwise we would find a solution. How extensive was our research? So we did a 3-country study in West Africa, in Ghana, and then in Sierra Leone. We also did some research in Mexico, and I showed some of the results of Mexico research in my presentation. And very similar to what we did in Mexico, we did in Argentina with some local partners as well. And at the moment, again, UNDP and ourselves and some of our local partners are replicating our West Africa research in East and Southern Africa. We're doing the same research in Malawi, in Mozambique, in Zambia, and in Kenya. The research has already been done. It's now a question of writing up the findings. So we will then have 6 countries in Africa to compare. And it will be interesting to see if there are any differences between West Africa on the one hand and Southern Africa. But beyond that, this is not an area outside of the US and maybe even in Wales where there's a lot of research on many things. Not much research has actually been done on especially the indirect costs of pretrial detention and excessive use of pretrial.
Yes, thank you very much. Probably I start with the question about the criteria about finding victims for infections. To my mind, there is no direct answer to the question. Just because the answer must be the positions of stakeholders, the regulatory system of justice, what they need to approach. Probably this is the quality of the budget, the fairness of the to put some money on this, and also it's in common sense, this is the understanding of justice of the society of each country. If you are talking about, if we are talking about the process of how to explain to legislators what it is, I can share that we prefer just simple table figures which get the article, which cost, which will be provided as well.
Where's the picture?
This helps in terms of discussion about what that can be.
That's your problem. We're paying for it. Where's
motivation of lawyers.
I'm saying we're paying a service for the regular people. Are you not going to that's what who's is the elder? Yeah, but I'm saying we need to sort it out. We're paying for the radio. Just tell your boss what it is.
That is what they never do. They come. The second is there is the openness of the system in terms of what they are contracted and they can choose which law they want to have within the system. Either it would be 2 calls per month during the week or probably also they have, at least we try to give them opportunity for ongoing professional development, trainings. In the circumstances of the EU criminal procedure code in Ukraine, we are probably the first who organize trainings within supported by international partners to lawyers in the country on the new tools can bring football within the process. And for the time being, the legal aid lawyers are first who attend such trainings and can apply new practices. In terms of the motivation of the state to raise the budget, this is an interesting question. But the answer would be, to my mind, the main reason why the budget are raised is the political instability in Ukraine. Because every new father came in the first, they tried to get new voters, and they are very positive about social investments in the country. Liberal aid also faced, I guess, post-Soviet culture of mistrust with people. That's why any defense provided for against the police, detentions against the prosecutors, investigators, they count, they try to use.
Thank you very much. We have those around 2 questions. Can I see the hands which you left here? Only those 3 hands, and we can be short. We can start here with the web. When we are done with it, some of the issues we can deal with in the next session. Teacher issues.
Thank you. My name is Artie Satyawan from the Philippines. And mine are actually comments, reflections based on what the speakers have shared. And I have 5, but I'll try to be very brief.
Yeah.
Number 1 is budget and resources are never sufficient. I think this is what many of our panelists are seeing. And if we need quality, meaningful legal aid service, we need to compensate lawyers. So that's one thing that has to be discussed. And I think this is precisely the topic for this pre-launch session. Second is, what is the question of adequacy? How can we say that the legal aid is adequate? We've heard of the designations, but what is the ratio per lawyer as to the number of cases that they actually handle? We've heard of so many statistics, but in the conference, I actually haven't heard of a statistic of how many would be the ideal number of cases being handled by a person, by a lawyer. The third is, how do we change the policy on, how do we influence the government policy on legal aid providers? The sharing of Maha is very revealing that ideally, the government would would say that they're sufficiently addressing legal aid if no other provider outside the government is doing it. It means that the government is doing its job. But we also heard the presentation regarding the state of New York, where private legal aid providers are actually being paid by the state. And that is an admission by the state that its services are quite insufficient. And the fourth one is, how to change the mindsets of the government. I totally agree with the socio-economic aspect. My only reservation with that is that by convincing policymakers that it's cheaper in the long run, we suffer the point that the whole point of legal aid is pushing for the right to fair trial, the presumption of innocence, the fundamental human rights of these people. And the last point is I support the intervention of the gentleman in front. That what about sustainability? Because we don't live in a vacuum. So even if we have resources for legal aid, what are the other programs of government to make sure that people who need legal aid would not need it again later on? They will go back to the practice. And how do we attract lawyers to go into legal aid, such as incentives for them to go into legal aid practice? Thank you.
Second, I'm not taking any other new hands on question for time. That was second and third was and then we will close it. Unfortunately, time is not on my side, and we can be sure.
Merci beaucoup. Et étant donné que la guerre nous fait défaut, je ne reviendrai pas sur certains points. Mais en ce qui concerne la question merci. Étant donné que nous avons des contraintes de temps, je vais me limiter simplement à faire une suggestion, puisqu'on parle beaucoup là du coût et du financement des systèmes d'aide juridique. Je pense qu'il faut aussi envisager la possibilité d'utiliser le produit des amendes pour financer des programmes d'assistance juridique. Actuellement, en Haïti, nous avons un projet de loi sur l'assistance juridique qui est en préparation et une des sources de financement que nous avons imaginé, c'est de proposer dans le code de procédure pénale et d'avoir un article qui va répartir le produit des amendes. Il y a une partie, un pourcentage qui va aller au trésor public et un pourcentage là pour les victimes d'actes criminels et le dernier pourcentage là pour financer les programmes d'assistance juridique. Donc c'est une suggestion là que je fais. Merci.
Yes, my name is Ade Ibaye. I'm Attorney General of Lagos State in Nigeria. And I'm commenting particularly on the presentation regarding the practice in the United States of America. Nigeria is also a federation, and it has a legal aid council which is at the federal government level. A state like Lagos runs a parallel scheme just because the federally funded one is not adequate. Now, in the US, I understand that it is left much to the states, so I want to know in particular what the role of the federal government is in legal aid services in the US, and if there are grants from the federal government, what are the criteria for those grants? And you spoke of a victim of crimes fund. I also want to know whether that is for the victims personally or for their legal defense. Thank you.
Very much, just to give the panel members 60 seconds each to respond to the 11 questions at the same time. Rep. Thank you very much.
I'll be brief. So I'm going to start with reverse order because it's directed to the U.S. Yeah, in the states, the federal government provides funding to the states based on their size. So generally, it's not discretionary, the federal dollars that go. But by and large, the states fund their own systems, their own ways. That's why there's a lot of disparities. And then there are sometimes discretionary grants where legal aid providers will apply for a small amount of money to do a pilot program or to fund evaluation, things like this. And I can give you more information as to where to see where that is on our website, which might be in your case. The Victim of Crimes Fund it's money to compensate the victims. There's also a small part of that that might be used for legal aid. And then just a few other things. To the question about, your question about how to set up the budget, I just would caution, you said, should it be based on the ability to fund? I would say no, just because none of us can fund properly. So if we started with how much we really have, I think all of us would set the bar quite low. So that's a practical matter, and it's appropriate to consider realistically what's possible, but at the same time, I wouldn't limit it, especially if you're starting at creating legislation. It's usually difficult to amend later, but I don't know the exact circumstances there. Or I won't answer this because I don't know the numbers, but there are caseload standards in the United States. My colleagues in the Philippines, I can give you that information later. I couldn't find it right here. Financial penalties to the gentleman from Haiti. Yeah, it's an interesting concept. In the United States, we're always concerned that we don't penalize the defendant. I don't think this is what you were saying. So, and the only thing that there are many jurisdictions in the United States who can levy fees and fines on poor criminal defendants that they may not even be guilty of the crime, but because they couldn't pay the fee, they're then even more caught up in the system. So using fees and fines, it just depends on who are being levied for those fees and fines.
I'd like to say about the budget and funding the system. For example, as he told us, I forgot the country. Haiti. In Brazil also, beside the budget, we have federal law providing funding, a special fund for the public defense. And this fund is mostly made up of a percentage of non-court costs like notarial services and costs of loss of suit paid by the losing party. Nowadays, that income is about 15% of the money injected by the state. So it's an important part of the budget of the public defense in Brazil. So improving this kind of other sources of budget is really important to maintain the system. And finally, the theme of the quality of arms is really important. And when we talk about legal aid, the theme of funds financing the budget is always present. But when we talk about prosecutors, we have many other things to deal with, but the budget is not the main thing. I really believe that the states must be as committed to the prosecutors, to the prosecution.
Which is very important for our legislation system of financing, criminal, also civil cases. In this case, we have quite tight connection substantial number of cases. We understand that the quality of human aid it's an issue that we need to find the maybe that was the question about the normal amount of cases where is one of the questions related to both. Let's see, I'm not ready to comment how to deal with doing things like knowledge, because we know when we try different approach, we will see what we will have together. But if we will be successful,
I was going to comment on the input that was made from the Philippines. If I understood you correctly, you were saying that we're talking about a fundamental right of people, a right to be presumed innocent, and that one might, there's a potential of demeaning that right by putting monetary value to that right. I accept that fully, and I think in this audience, that's completely appropriate. I mean, even if we couldn't show that there would be any potential savings to be brought by providing legal aid, it would be a pure expense. I think we would all still be poor. The presumption of innocence is very important. And we know from countries where the criminal justice system functions really well, such as in Wales, for example, that over half of all pre-trial detainees are eventually acquitted, or once convicted will not get a custodial sentence, so they can commit to a pretty minor offence. And that ratio is likely to be much higher in other cases. However, unfortunately, most politicians and media houses and many members of the public don't see it that way. I think once somebody's been arrested, they're probably most likely already guilty anyway. And that one has to come with other arguments, be they public health arguments, be they policy-related arguments, which are appealing to them, arguments which they can identify. So it's a bit of a pragmatic approach, but it's certainly not my intention to try and undermine the principle.
Thank you very much. On the very note, can we give a panel as of applause, please?